Hello everyone, I hope you are doing good and must have seen the GS2 paper. Not for a surprise, the question were a mix of both conceptual understanding as well as a good amount of current affairs we could see. Let's try to see some of the polity questions which I'm going to discuss and give you a structure of the answer. Not exactly teach you the topics because you must be knowing them already. You have been covering them in the newspaper, but rather try to give you a structure of the answer itself. With that in mind, let's look at the very first question that they have asked this year, which is examine the need for electoral reforms as suggested by various committees with particular reference to one nation, one election principle. Now, this is a very intelligently framed question. Looking at the topic of one nation, one election, I believe many would just focus on the idea of one nation, one election, that what is good with it, what are the pros or what are the cons, what are the limitations, etc. However, if you see in a deeper sense the question, the examiner is not asking you exactly about one nation, one election. You may write it, that we will see as a part of value addition. However, what the examiner is expecting you to write is about the various recommendations that various committees have given till date in order to promote the idea of one nation, one election. So, as we see, the answer structure has to have three parts, as we already know: introduction, body and conclusion. As far as introduction is concerned, we can very well write about the idea of one nation, one elections, or what is also called as simultaneous polls. And we can very well define one nation, one election, that it is the conduction of elections simultaneously to both the Lok Sabha at the central level and the state legislative assemblies at the state level. Rather, one added effect to it is what we see in the recent report of the Ramnath Kovind report, which has been submitted, which even talks about phasing it in the next 100 days to align even the local polls. Now, a student may prefer to write about the definition of what one nation, one election is, or even talk about the contextual understanding of it. So basically, every year in India, we see 4 to 5 general elections being held, and the cost of this is very, very high. It is not only the cost, but rather it compromises to a larger extent the governance paradigm as well, because every time there is an election, the model code of conduct comes into action, and the moment the model code of conduct comes into action, everything turns into the election paradigm and completely governance is compromised. In order to majorly address these 2 points so that the governance goes up and the cost goes down, the current government is strongly supporting and advocating the idea of one nation, one election. And the question very rightly identifies that there are many committees and commissions which actually speaks about it. So you are not supposed to write about the advantages and disadvantages of one nation, one election in the body, but rather in the body part, to start with, you can write it in 2 formats. If at all you want to introduce one nation, one election, then briefly write about the positive and negative of it. The major positives of it would be to control cost, as we discussed, to bring back the focus on governance, to bring in political stability, and to a larger extent to reduce politicization and polarization in the society. You know very well, whenever elections are there, there is a good amount of charged environment in the country. However, there are good amount of negatives also when it comes to one nation, one election, and many of them are having in different formats. For example, we have a good amount of constitutional challenges. For example, Article 83 or 172, which talks about the duration of Lok Sabha or the state legislative assembly, which fixes a maximum duration. However, there is no such writing or statement or provisions which talks about the minimum part of it. We very well know, according to the democratic principles, the Council of Ministers is accountable or collectively answerable to the lower house, as a result of which, when they lose confidence, they can be dissolved. Similarly, we have to make good amount of changes in Article 85 and 174 also, which is the power of the president or the governor in order to dissolve the houses. Apart from that, we also have to look at Article 356, which is about imposition of precedent's rule. Now, these are the bigger challenges when it comes to the constitutional part. As far as the legal challenges are concerned, we also have to make changes to RPA 1951, RPA 1952, and some changes to the conduct orders also of 1961. At the same time, we also have to understand the logistical challenges. For example, the amount of security personnel which are needed in order to conduct elections in such a vast range, we have to look at what much, or how much rather, logistical feasibility lies. At the same time, we also have to look at the behavioral challenges. For example, when simultaneous election takes place, the national politics, it takes the center stage, and there is a great amount of problem when it comes to the local elections or local issues. Now, when we talk about the behavior of the voters, many a time it is very, very difficult to state that a voter is aware enough to make correct choices at the central part as well as the state part. We have evidences for both the things, wherein the voter is not able to make choice, and at some places where the voters are able to make choice. And the perfect example would be that of Odisha and Aam Aadmi Party, BJD in Odisha and Aam Aadmi Party in Delhi. The vote share of BJD actually increased in 2 consecutive elections, wherein the voters were, because there were simultaneous election, the voters were able to vote for a different party at the central level and vote for a regional party in the state level. From 36% it rose to 44%. However, we have the other school as well. Once you briefly introduce the positive and negatives of it, the second part of the body is actually what the question is all about, which should be the major part, which talks about recommendations as far as one nation, one election idea is concerned. We can very well go in a backward form by first writing about the Ramnath Kovind committee, a high-powered committee under him was constituted, which has come up in March 2024 and talks majorly about 3 things. Number 1, it talks about phased elections. So it talks about, in first phase, we should try to align or simultaneously conduct the Lok Sabha polls with that of the state legislative assembly, and in the next 100 days, as I told you in the introduction part, to actually align the local polls as well. The second recommendation that it talks about is to make constitutional challenges, is to take care of constitutional challenges, where it deals with Article 83 and 172 and also suggests or rather recommends to insert a new provision, Article 82A, for states, where if the state legislative assemblies are made after a particular date, then they are to be dissolved in due period, so to align the next election with that of the Lok Sabha polls. It also talks about the single electoral list. Rather than using different electoral list, it talks about using the same electoral list. That is what the Ramnath Kovind committee talks about. But it is not the only committee which talks about it. We can very well talk about the law commissions as well, which have in multiple time suggested the idea of one nation, one election, but at the same time have also made it pretty much clear that it is very, very difficult because there are many constitutional challenges, like definitely that of federalism. And you already know that federalism, though it is not written anywhere, is one of the features of basic structure doctrine as identified in the S.R. Bommai case. Now the case also deals with floor test in order to look at majority of a particular ruling party and whether it should continue with the governance or not. Now, simultaneous polls are a direct challenge to federalism. At the same time, the center might become more powerful with more of centralizing tendency when it comes to one election, one polls. At the same time, it talks also about the empowerment of Election Commission of India, especially in reference to Article 324, which talks about superintendence, direction and control of election, which is the Omar versus Trivedi case. So the Law Commission, it explicitly talks about making good amount of changes to these. Getting it? The Law Commission is again not the only one. Even the Election Commission itself, along with a parliamentary standing committee on personal public grievances, law and justice, also talks about many kind of reforms. And one of the underlying reform is that rather than making a cycle of 5 years in order to have one nation, one election, both of them, they suggest about a phased election model of 2.5 years. Along with the changes that we have seen are to be made to Representation of People Act, both 1950 and 1951. So you can underline all of these things in the answer. At the same time, the National Commission to review the working of Constitution also talks about making desired changes on the same lines of addressing the idea of federalism, wherein the states or the state government or the state legislature is an expression of the democratic will of the people, and center should not engulf that will, or center should not take away it. So state have the right to represent the democratic will that they have got from the people. Second, it also talks about the same Representation of People Act, both 1950 and 1951, to be amended accordingly, and also talk about constitutional changes. Especially it talks about the usage of Article 356, which has to reduce down or even to come up with more ideas. For example, the ARC talks about an idea of local emergency rather than state emergency. We can talk about these kind of innovative manner. Similarly, a working paper of the Niti Aayog of 2018 also talks about the what, why and how. This is the title of simultaneous elections. And it also talks about taking care of the same constitutional, legal, logistical as well as behavioral changes, even including the idea of a voter awareness. So this is going to be the crux of the answer and not exactly the positive and negative of simultaneous polls or one nation, one election. You have to understand the question very smartly. Now, once you have written it, you have got the idea to conclude it. Now, we can very well conclude it with some best practices around the globe. Also, you should understand that one nation, one election is not a unique idea to India. Rather, countries like South Africa, Sweden, United Kingdom, they have already been following it and the success has been mixed. It is not a model which is like supremely proven or has been very, very efficient. Rather, the results have been mixed. At the same time, we can talk about many of the electoral reforms we can bring so that the present system of elections do work effectively. We can talk about getting better or clean finances, which is clean money. We can talk about the affirmative or positive way of no confidence motion that is used in Germany, which does not disturb the tenure of the government but still allows for change of government. We can talk about South Korea's model of campaign finance so that less and less amount of black money is indulged. We can definitely talk about Australia's preferential mode of voting in order to have better representation for stability of government. If you look at this question has good amount of scope to write whatever you have read in the newspaper or magazines, etc., in order to take care of the issue. Getting it? Let's go to the next question. So the next question that we're going to look at is all about the cabinet system and how the cabinet system has been marginalizing the parliamentary system in India. So the question states, the growth of cabinet system has practically resulted in the marginalization of parliamentary supremacy. Elucidate. So again, dividing the question into its requisite structure, which is intro, body and conclusion, we can very well write about what is cabinet system and what is parliamentary system. This can very well become the introduction. As far as the body part is concerned, here we have to write how the cabinet system has been marginalizing, how it has been sidelining the parliamentary system. So we have to definitely talk about some strong points of the cabinet system and also talk about certain weak points of the parliamentary system, and then talk about the importance of parliamentary system and a way forward or some suggestive measures in order to give parliament its due space. This is exactly the demand of the question. Now, we can very well introduce the answer by saying what is a cabinet system, and you very well know that cabinet system is an executive structure which comprises of the prime minister along with some minister, generally the cabinet minister, and is the core of decision making in parliamentary form of government. However, parliamentary system or parliamentary supremacy is all about the supremacy of the legislature in the law making domain. Right? This is the introduction. As far as the body is concerned, where we have to write how the cabinet system has been growing up, we need to write down about the strong point of cabinet system. So we need to write down the strong points of the cabinet system. And the very first point is the dominance of executive. Dominance of executive. This is a hard truth that we very well know, that the executive dominance actually controls the complete legislative agenda. The complete legislative agenda in the parliament is dominated by that of the cabinet or the executive. Now, here more than the point, what is important is actually to write down the example to substantiate it. For example, look at the GST Act. It was completely in favor of the executive because of the dominance of executive. The GST Bill 2017 made rounds when the parliamentarians, I mean the opposition party, were not having a lot of say, and they used to criticize it out of the parliament. Whereas inside parliament, because of executive dominance, we could not see a great amount of discussion. At the same time, the practical majority party rule, along with the idea of anti-defection law, has also reduced the members to just numbers. And as such, with majority party, it is almost next to impossible to actually take a say of the opposition party members or to have a participation in order to facilitate the parliamentary supremacy. And the best example over here would be the farm laws of 2020. The farm laws of 2020 are best of example. The third, we can always talk about the ordinance route. And you very well know about the ordinance route, which is used under Article 123. And very well the example can be the land acquisition ordinances, which were re-promulgated also multiple times without taking into the idea of what the opposition has to say, which we saw in the year 2014. Apart from that, we can see that the question hour, the major time when the parliament actually does its work of deliberation, has been coming down. Isn't it? The question hours has been coming down drastically. At the same time, there has been good amount of reduction in the parliamentary scrutiny. we see both of the things actually happening at the same time. Because if you remember, during the COVID-19 time, the question hour were reduced drastically because the legislative agenda is fixed by the executive itself. As such, the opposition leaders, they found it very, very difficult to question the government on the policies and the handling of the crisis, if you remember that time. Getting it? At the same time, we also see good amount of parliamentary limitation. So we have to talk about some negative of parliament also. For example, expertise of parliamentarians has been reducing. At the same time, we see the sittings of parliament to be reducing. Now, there are major reasons for it, and one of them is the position of the speaker, isn't it? So we can look at that part. For example, if you look at the Citizenship Amendment Bill, we can see, although the parliamentarians made good amount of noise outside it, because of lesser number of sittings and in some places less of expertise also, we could not see parliamentary supremacy. So laws were dominated by the executive, by the cabinet, and not by parliament. At the same time, we also saw some strong cabinet committees which actually sidelines the parliamentary committees or the parliamentary supremacy. For example, the complete decision of Balakot strike was taken by the Cabinet Committee on Securities, and no parliamentary debate actually were held on it. At the same time, we also look at certain personality trait, and exactly we look at powerful leaders. Leaders like that of Indira Gandhi or Narendra Modi, they do attract concentration of power, and as such, the cabinet becomes much stronger than parliament. Isn't it? Now, these are the reasons. And you know the other reason, like the money bill path. The best example would be that of the Aadhaar Act. Right? So, even the money bill path has been taken. So, we have to write these things where to say that how the cabinet is actually sidelining the parliamentary supremacy completely. Now, we should talk about how to bring back the lost glory of parliament. So, we should talk about way forward. And definitely the way forward needs that departmentally related standing committees, they should be composed more and more. At the same time, the speaker shall be impartial, or rather, once a speaker, always a speaker. The British Convention shall be used, which means there should be more and more of legislative debates. Also, we can talk about increasing the number of sittings in parliament. This is also important. More it increases, more number of discussion are happening. At the same time, we have to make requisite amendments to the anti-defection law so that our members are not reduced to numbers. And also, we should encourage the idea of constructive criticism. Somewhere this is also missing. As such, we see that the cabinet bypasses the parliament every time an important decision has to be taken. Clear? I hope this makes sense. Let's look at the next question, which is a pretty simple one and talks about the Indian secular state and its comparison to that of the US secular state. Now, the preamble itself makes it pretty clear how the Indian secular state is different from that of Western secularism, and a good amount of its idea comes from the idea of Mahatma Gandhi, who has stated how religion in India is pretty differently held in India compared to that of US, which means Western and Eastern secularism. Now, if you look at the question says that explain about the Indian secularism and then compare it to that of the US secularism. It's a very easy question. We can definitely introduce the question by talking about Eastern or Indian secularism, wherein you know state and religion are not exactly separated. An individual have their right to religion. At the same time, the state does not have any kind of official religion. The state does not have any kind of official religion. As far as body is concerned, we have to talk about the difference of treatment of state and religion in United States of America and that of India, as far as different factors are concerned. For example, if you talk about the US secularism, it was majorly held through. See, both the country have constitutional principles for secularism. In US, it is the First Amendment which ensures secularism in United States of America, and it brings in two things. It brings two clauses. One is called as Establishment Clause, which says that state should not have any kind of official religion or state should not be party to any religious activity. And the other is called as what is called as Practice or Exercise or Free Exercise Clause, which means individual do have the right to exercise whatever religion they want to go for. Now, all of you know already that this is called as positive, this is called as negative secularism, and this is called as positive secularism. Why positive? Because state has a role in religion, and state has a role in religion because religion is integral to the life of people, and people will only develop, only grow when religion grows. As such, state, which has a duty to work for growth of people, ultimately has to work for reformation of religion. Whereas in case of USA, it is negative, hence there is a strict separation between state on one side and religion on other. Now, the different things which actually makes both of them spaced apart. For example, if you look at state and religion, here there is a complete division. Here we can see state having a role in religion. For example, if you look about religious freedom, in the first one, the constitution guarantees about religious freedom of everyone, but also adds to, in India, it adds to that of more of rights for minorities. Whereas in US, there's nothing called as minority, you directly go for a strict separation between state and that of religion. As far as role of religion in public life is concerned, in case of India, religion do have a role in public life, especially when there are any kind of social stigma or any kind of social limitation. The state has rather active role to come into the life or rather religious activities and change it or rather reaffirm it or change it in a progressive manner. Whereas in US, unless and until it is not challenging law and order, it cannot come in the affairs of religion. Which means in India, people do expect the state to also come and fix religion. Whereas in US, these people take religion completely as a personal affair, whereas state is active in the public affair. Similarly, we can very well talk about financial support, that in US there is a strict no to financial support, whereas in India, the state can partially even fund religious institutions and in many a time also helps in the administration of it. However, in US it is completely separated. So these are the basic things which we can talk about it. It's a very easy question. And as far as conclusion is concerned, so you can write everything, but I believe today's time why this question has been asked, after I think 2016 when they asked a question of what France can learn from Indian secularism, I think in conclusion it is very, very important to write that with more and more of cosmopolitan world, we understand that people coming from multi-religious groups are becoming a reality to all the states. So the background where the strict separation between state and religion was there because of mono-religious communities is changing today because of globalization. And as such, the traditional handling of the Western state, where state and religion are completely separated, is facing challenges that we can see in Europe, especially France, etc. So today, it's the Indian secularism, which is a Sarva Dharma Samabhava, which stands at the locus standi, or rather at a central point to actually give many things to other countries. So when we say that India is going to be the Vishwaguru, you can very well talk about the concept of Sarva Dharma Samabhava and end this answer. It's a good answer in the present context, right? Okay, now let's look at the last question that I'm going to take or rather discuss with you, which is regarding right to privacy. And right to privacy, and especially it talks about the right to privacy in the domain of DNA test for baby which is in the womb for paternity test. So the question is, right to privacy is intrinsic to life and personal liberty and is inherently protected under the Article 21 of the Constitution. Explain. In this reference, discuss the law relating to DNA testing of child in the womb to establish its paternity. So if we look about the structure of the answer, the introduction can be very well about what Article 21 is, but more than that, just writing the constitutional provision won't suffice, but rather we have to write about dignified existence of individual. And dignity needs a host of characters, including privacy. Then in the body part, we have to expand on first part, that right to privacy is intrinsic to a dignified life. In the second part, we have to talk about DNA testing of child in the womb for parenting, test of parenting. As far as this part is concerned, it is pretty easy. I hope you can write it. You can start with the Supreme Court in the Puttaswamy case, setting aside the judgment of that of MP Sharma as well as Kharak Singh case, held that right to privacy is a fundamental right coming under part 3 of the Constitution, fundamental right itself. And it is intrinsic to the dignified existence of an individual, because body of an individual is the sanctum sanctorum of an individual, and privacy is the key to maintain the sanctity of that body, right? So we see that right to privacy has come up as one of the most important inferred rights under Article 21. This part I hope you can make good amount of justice. Whereas this is the part that we have to talk about. Now, when we talk about a DNA testing of a child inside womb, and especially for parenting and not for any other purpose, we see there are 3 stakeholders. One is the unborn child. Second is the mother inside whose womb is the baby, and the third one is the alleged father. Now, apart from the alleged father, you can very well understand that right to privacy is completely compromised for these two. The mother has the body inside which the baby is there, hence it is an infringement to the right to privacy of the mother. At the same time, the unborn child also has to go through psychological trauma and is completely an infringement of her right to privacy. Getting it? Now, as far as laws are concerned, we see that the PC-PNDT Act, it puts heavy regulations on any kind of experimentation with the unborn. So there is nothing which talks clearly about the DNA testing. Getting it? At the same time, if we talk about any other law, we actually do not see any kind of direct reference to DNA testing. We do not see that part, right? But at the same time, a bill has been introduced very recently, which is the DNA Technology Use and Application Regulation Bill. It may provide some guideline. However, the Supreme Court has been very much vocal about not involving the child in any kind of a dispute where the child is not a direct party. So a collateral impact to the child doesn't give good amount of case for anyone to go for any kind of a DNA testing. As such, the Supreme Court has made it clear that unless and until there is no other way, or rather it is the last resort, then only DNA testing for child, a child, actually it talks about child completely and not exactly a child in the womb. So it says that DNA testing should be regulated and limited as far as possible. At the same time, when we talk about the conclusion of it, we can very well write about how Article 21 and privacy leads to more of democracy and freedom. And we can talk about that today in the digital world, how privacy is one of the most important tool. And at the same time, we do understand that it is the very right of an individual to determine what is being done with him or her, at least at a time when he is of no decision-making age. And that's why the Supreme Court has also made it clear in multiple cases multiple cases in the past, for example, the Bhavani Prasad Jaina case or many other cases where it has said that the mother has to take a call, but then this should also be the last resort, right? These are the 4 questions that I wanted to discuss with you. I hope you understood how to write the answer, and I believe you should write them. The more you write them, the better you will understand them.
So the question says this: explain the reasons for the growth of public interest litigation in India. As a result of it, has the Indian Supreme Court emerged as world's most powerful judiciary? So obviously this question has 2 segments. First of all, you will have to enumerate the reasons for the growth of public interest litigation. The second part is more analytical in nature and would require your opinion as to whether, due to public interest litigation, Supreme Court has emerged as world's most powerful judiciary. So coming to the first portion, so it's straight, explain the reasons. So the most important reason, I have enumerated some points here. The most important reason which you will find that why public interest litigation emerged as an instrument of court intervention. The rights deprivation and the inability of ordinary citizens to approach courts to claim their rights. So usually a person who is educated, well off, if his rights are violated, he can file a writ petition before the High Court. He can approach even Supreme Court under Article 32. But what about poor people, marginalized, powerless? For them, they do not have the voice to go to the court, nor they do have the entitlement or resources. So persistent rights deprivation on a massive scale, that happens to be one reason why judiciary was approached, citing the sufferings of these people. So one among the foremost cases in the history of public interest litigation, that is Mumbai Kamgar Sabha case of 1976. So industrial workers in and around Mumbai, they were being denied their bonus, minimum wages, persistent suffering. That constrained an organization named Mumbai Kamgar Sabha to approach Supreme Court, and it is regarded as the first public interest litigation. Even before the emergence of public interest litigation as a solid instrument of judicial intervention, this case came up, paving the way gradually for the emergence of PIL. So one of the pioneering cases wherein Supreme Court interfered on the plea made by Mumbai Kamgar Sabha in 1976. Likewise, Sunil Batra versus Delhi administration, another pioneering case of 1978. So this case was about Sunil Batra happened to be a prisoner who witnessed a condemned prisoner, a death row prisoner, being subject to physical abuse to extract money from his relatives who do come to visit him. So Sunil Batra sent a letter to a judge of Supreme Court, and that letter was taken as a plea by the judges of Supreme Court, and they initiated proceedings. And Sunil Batra versus Delhi administration of 1978 happens to be a landmark case wherein Supreme Court underlined that even if a person is a death row prisoner, even if he is a condemned prisoner, his right to life cannot be in a unlawful manner, cannot be diminished by way of inflicting torture. He does not have to suffer the torture by the jail authorities. So law was declared by Supreme Court in 1978. So rights deprivation and the inability of the ordinary citizens to approach court. So Sunil Batra himself was not affected. He saw somebody getting affected, somebody getting tortured, and he sent a letter to Supreme Court, and that was taken on the file of Supreme Court, and the proceedings were initiated. Secondly, judicial activism happens to be a major reason why public interest litigation arose. Judicial activism, as you know very well, is nothing but the activism displayed by judiciary, wherein it goes beyond the zone of passive adjudication and it enters into the domain or turf of executive and legislature by way of passing directions to government, even with respect to certain legislative initiatives like introduction of bill and all. So judicial activism happens to be a reason why PIL got emerged. Judicial activism and the dilution of concept of locus standi. Locus standi means unless your rights are affected, you cannot go to the court. So when you file an Article 32 petition, when you file an Article 226 petition, the first question that would come up, what is the cause of action, how your rights are affected. So unless you do have a standing before the court as a one whose rights are affected, the court will not hear you. This used to be the traditional conservative understanding of locus standi. So you have to be affected to reach the court. So Supreme Court, in an age of judicial activism, diluted the concept of locus standi and in many a case allowed people who are moved by the plight of the poor and powerless to initiate proceedings before the court. Like SP Gupta versus Union of India, 1981, though this case is not about massive rights deprivation, it's essentially a constitutional case with respect to the appointment of judges. So when a high court judge was transferred to another high court, a lawyer practicing before a third high court filed a petition challenging the exercise of power by president, that is unlawful, what he felt as unlawful transfer of judges. So transfer of a judge. So here in SP Gupta versus Union of India, Supreme Court for the first time in theoretical terms diluted the concept of locus standi and declared that even if a person is not affected, but still in public interest, he can approach court. So the expression public interest litigation was found in SP Gupta case that gradually paved the way for the emergence of public interest litigation as an acceptable, popular, remedial measure for empowering the poor and the powerless. So I was telling you that how judicial activism and dilution of concept of locus standi resulted in the emergence and establishment of public interest litigation. Another landmark case here is Husainara Khatun versus State of Bihar, 1979. So a lawyer named Kapila Hingorani of Supreme Court, being moved by some articles and disclosures about the plight of jail inmates there in Bihar. Thousands of under trial prisoners, they were languishing without bail due to their inability to furnish bail bonds. They were being tortured. They were not being heard by anybody. No courts were hearing. So such people who never thought that they would ever come out to see the light of the day, they were given relief due to the initiative taken by Kapila Hingorani, and the case was heard by Supreme Court in Husainara Khatun versus State of Bihar. So the year is of 1979. Supreme Court ordered massive release of 40,000 under trial prisoners and thereby upheld right to life with dignity of those people who remained unheard. Likewise, another reason why public interest litigation arose is the administrative apathy. Means administration would be focused on their own priority areas, and many a time the requirement to have certain legislative initiatives, they remained unseen, unheard. So in the landmark Vishakha case, Vishakha and others versus State of Rajasthan, 1997, which happened to be a public interest litigation, in that case, Supreme Court requested the government to introduce a bill to protect women from sexual harassment at workplace, and nothing was done despite repeated requests made by the court. No bill was introduced in Parliament, as a result of which Supreme Court invoked its power under Article 142 and issued guidelines which would have the force of law, so that every work setting would have what is known as internal complaints committees to hear sexual harassment related grievances and action thereafter to be taken by way of those proceedings. So in Vishakha and others versus State of Rajasthan, due to consistent administrative apathy, we are not blaming government as such, but because of their own priority areas, they remained insensitive to such the need to have legislative initiatives. Even on the face of the court request, no such bill was introduced, resulting in judiciary legislating by way of guidelines by invoking its special power under Article 142. So Vishakha case happens to be one of the landmark interventions in the history of public interest litigation. Thereafter, another reason is the initiatives taken by public spirited individuals and organizations. So MC Mehta happens to be a crusader for environmental protection. For example, pollution, how it is affecting Taj Mahal, the protected monument, and thereafter many cases. Even today, Supreme Court has a running case, a pending case, which is being continuously heard. That is MC Mehta versus Union of India. So people like MC Mehta, Kapila Hingorani, I earlier referred to Husainara Khatun case, initiative of a lawyer, a lady lawyer who felt moved by the plight of the inmates of Bihar jails. So Kapila Hingorani, People's Union for Civil Liberties, Center for Public Interest Litigation. So unless such initiatives are taken by individuals and organizations, the court will not be in a position to take cognizance of such developments. Court needs to be appraised, and many a time such news do not get published. Society in general is not aware of such developments, such plight of the poor and the powerless. So we need to appreciate the initiatives taken by such people and organizations as a clear reason behind the emergence and fostering of public interest litigation in India. Then suo motu proceedings initiated by court. So these days you see, like in RG Kar Medical College case, you will find numerous similar cases wherein Supreme Court initiated proceedings by itself by way of registering writ petition by its own motion to remedy the grievances of the ones whose rights are violated. And this is also a reason why PIL got greater credence. Then welfareist legislation and weak implementation. We do have numerous welfareist laws like Minimum Wages Act, Bonded Labour Act, Maternity Benefit Act. However, despite such strong statutory framework, more often these laws are not strongly implemented, as a result of which the people who are directly affected, they would not be in a position to reach the court, but public spirited individuals and organizations like Mumbai Kamgar Sabha, so Bandhuwa Mukti Morcha case. So in such cases, the judiciary interfered to ensure that these legislations are implemented strongly. So these could be cited as reasons why in India public interest litigation emerged. Now coming to the second portion of the question, as a result of which has Indian Supreme Court became the world's most powerful judiciary? See, it's an opinion-based question. You can have your opinion, but you establish it with clarity. So in my view, it's not necessary that what I am sharing should be the sole answer or angle of understanding that question and its answer. So in my view, whether public interest litigation resulted in the emergence of Supreme Court as world's most powerful judiciary. See, Supreme Court became world's most powerful judiciary because of constitutional provisions which conceived a Supreme Court which is extremely powerful to protect Part 3. So, constitutional provisions and the interpretation rendered by Supreme Court resulted in its establishment as world's most powerful judicial institution. For example, Constitution conceived a unified judiciary for India with Supreme Court at the top, exercising judicial control over all courts and tribunals in the territory of India. So even a magistrate court order can be directly challenged before Supreme Court under Article 136. So in no other country, a federal country with some marginal exceptions, you will find such powers exercised by the highest court of the land. Likewise, appointment of judges in India happens through a process where judiciary has primacy. Under Article 142, we talked about Vishaka case. Under Article 142, Supreme Court has the power to pass any order to do complete justice. So in an age of public interest litigation and judicial activism, Supreme Court consistently made use of Article 142 to secure justice to the poor and the powerless. Then Article 144 that declares it is the utmost constitutional duty of every civil and judicial authority to act in aid of Supreme Court. Then Keshavananda Bharati case, that is basic structure doctrine. That happens to be the highest watermark of judicial activism. Of course, judicial activism got established as a phenomenon much later, but still you will find the the beginning of judicial activism. Some people even do view it as the high watermark of judicial activism in Keshavananda Bharati case, which is also a classic example of the highest extent of judicial review being exercised. So, Supreme Court became world's most powerful judicial institution on account of all these reasons. However, public interest litigation became a tool by which Supreme Court could express its activism. So, PIL did not make Supreme Court the most powerful judicial institution. However, PIL became instrumental in transforming Supreme Court as the most interventionist court of the world to secure rights of its poor and powerless citizens. So, Supreme Court made use of public interest litigation to exhibit its power for the sake of protecting public interest, for the sake of upholding rule of law and justice. Of course, PIL also at times it becomes private interest litigation, vested interest litigation. So, such initiatives were deprecated by Supreme Court, condemned by Supreme Court from time to time. But still, coming to the answer to the question, PIL became a tool for intervention by Supreme Court. It became a modality by which Supreme Court interfered to guarantee justice to the people who would not otherwise be able to reach court to secure their rights. So, this is how you can respond clearly to the second part of the question.
Now, let's start with the next question, that is, explain and distinguish between the Lok Adalats and the arbitration tribunals, whether they entertain civil as well as criminal cases. The introduction for such a question can be started with that the institution of Lok Adalat and arbitration tribunal aim at resolution of conflicts, outside the traditional court system, by following the principles of ADR, alternative dispute resolution. In fact, in the bracket, some of the principles like mediation, arbitration, etc. can be mentioned also. Now, as per the demand of the question, we have to distinguish between the institution of Lok Adalat and the arbitration tribunals. So, since there is not much of the scope in 150 words, so such kind of differences of course can be provided by making a table. On one side, feature of the institution of Lok Adalat and arbitration tribunal. In terms of its definition, the Lok Adalats provides an informal forum for resolution of conflict, whereas the arbitration tribunal, they are more formal and structured. They are more formal and they are more structured of the body, and the nature of the institution of Lok Adalat, it is voluntary and conciliatory. Voluntary and conciliatory means that here an individual has to approach the institution of Lok Adalat of its own, whereas in case of the arbitration tribunal, the nature is formal as well as adjudicative. It is formal as well as adjudicative. Then, in terms of the composition, the institution of Lok Adalat is comprised of lawyers, head of the Lok Adalat, and other social activists. They try to find an amicable solution to the conflict. In case of the administrative tribunal, it is majorly dominated by the administrative functionaries along with the judicial officials. Then, apart from this, the procedure of the institution of Lok Adalat, it is simple and more focused. With respect to the arbitration tribunal, this procedure is more structured and based on rules and regulations. The decision of the institution of Lok Adalat, if we talk about the nature of the decision, in fact, so the nature of the decision of the institution of Lok Adalat as well as of the arbitration tribunal, both of them are binding in nature. But here it is binding by means of consensus. That means even the head of the Lok Adalat is pronouncing an award when both the parties are agreeing to it. And here in case of arbitration tribunal, the nature of this decision is binding by means of the regulations and laws. It is also binding, but it is binding by means of regulation and laws. Further, there is not much of the cost that is incurred in the institution of Lok Adalat. It is more economical, and generally no fee as such is levied with respect to the institution of Lok Adalat. But in case of arbitration tribunal, minimum fee is the one which is levied. So generally in Lok Adalat this fee is not levied, but here in case of the arbitration tribunal this fee is levied. And also in terms of the formality of the decisions, what we observe is that these decisions are less formal on part of the institution of Lok Adalat, and they are more formal and structured with respect to the arbitration tribunal. So this is how we can differentiate, since we are not blessed with the leverage of the word limit in 150 words. So this is how we can differentiate between the institution of Lok Adalat and the arbitration tribunal. Further, the second part of the question, it majorly deals with that whether they can entertain civil as well as criminal cases. So the institution of Lok Adalat have wider set of jurisdiction over civil matters, and even in the compoundable criminal offences, or even in the compoundable criminal cases, they have a very wider set of jurisdiction. Like this wider set of jurisdiction of the institution of Lok Adalat extends over the areas like matrimonial disputes, family disputes, property related disputes, motor vehicle accidental claims, along with the motor vehicle accidental claims, they can also try the insurance related matters, transport related dispute, post office related dispute, the dispute related to land pattas, etc. and in some of the compoundable criminal cases also, the jurisdiction of Lok Adalat extends. Jurisdiction of the Lok Adalat extends. In fact, the Lok Adalat is having a statutory recognition under National Legal Services Authority Act of 1987, and all the powers that are vested in the civil court, all the powers that are vested in the civil court are also vested in the institution of Lok Adalat. Whereas on the other hand, the arbitration tribunal generally try civil cases. They try civil cases, and these civil cases are administrative in nature. Administrative in nature, like they can be related to service matter. Within service matter, like promotion is there, termination from the service is there, promotion, termination, penalties, etc. Such cases can be tried by them, and they can also levy penalties. They can also levy penalties like NGT, National Green Tribunal. So it is one such arbitration tribunal with respect to resolution of the dispute with respect to these environmental laws, and accordingly they can also levy penalty. So they don't try the criminal cases. The institution of Lok Adalat can try the criminal cases. Now, what we see is that in the conclusion, how it can be concluded? In the conclusion part, we can refer that the institution of Lok Adalat and the arbitration tribunal aim at constructive conflict resolution, but the institution of Lok Adalat is more informal in nature, and accordingly it is more accessible. It is easily reachable also because of its informal nature, whereas the administrative tribunals are complex with respect to this institution of Lok Adalat. But again, both of them are aiming at constructive conflict resolution. The next question is, the duty of the CAG is not merely to ensure the legality of the expenditure, but also its propriety. Again, it is a simple and direct question that has been asked in 150 words. So again, the introduction part of such questions can always be, there in fact can be direct introduction like, the CAG is regarded as the head of financial administration in accordance with Article 148 of the Constitution, whereby CAG is ensuring the transparency, accountability of the public finance, or with respect to the utility of the public finance, by assessing the legality, regularity, as well as validity, by assessing the legality, regularity, as well as validity in the management of public finance. That how the legality, regularity, as well as validity can be ensured in the management of public finances. And accordingly, this CAG is performing various kind of audits also, like efficiency audit, compliance audit, performance audit, etc. So the variety of the audits can be performed by the CAG in accordance with Article 148, where he is regarded as the head of the financial administration. Now the question talks about two aspects, legality of the expenditure and also about the propriety of the expenditure. So in the main body of the answer, first of all, we will be focusing on the legality of the expenditure. legality of the expenditure. The CAG ensures that the institution of CAG ensures that the money is withdrawn out of the consolidated fund of India with proper approvals, in accordance with the law of the Parliament. In accordance with the law of the Parliament, thereby legitimizing such a withdrawal. Thereby legitimizing such a withdrawal. Also in accordance with Article 279 of the Constitution, the certification of the CAG is final and binding, with respect to net proceeds. With respect to net proceeds, the certification of the CAG is final as well as the certification is binding. So one aspect of it is legality of expenditure, but majorly they have focused this question around propriety of the expenditure. Propriety of the expenditure. This propriety of expenditure is ensured by the institution of CAG by means of propriety audit. By means of propriety audit, and the purpose or the major intention behind the propriety audit is to examine the financial transactions, of the government on the parameters of appropriateness, reasonableness, and justified or justifiable expenditure, or as justifiable expenditure. Now, so here he is examining the financial transactions of the executive on part of appropriateness, reasonableness and justifiable expenses or justifiable expenditures. Now the element of appropriateness is that whether the spending was suitable, and the spending was suitable means that it is aligned with the objectives of the policy. It is aligned with the objectives of the policy for which the money was withdrawn. The reasonableness means that whether the expenditure that has been made with respect to the policy have valid reasons. Then justifiable expenditure here means that can there be alternative or rather cost effective alternatives. That means there could be some other ways, cost effective alternatives where that money could have been spent in the different manner. So overall, taking a holistic viewpoint with respect to the propriety audit or propriety of the expenditure, what we can say is that by means of propriety audit, the CAG is questioning or checking the wisdom of the state or wisdom of the executive specifically in incurring any kind of expenditure with respect to formulation or implementation of any particular policy. Now the objectives of the propriety audits, the second heading of course under that would be objectives. The objectives of the propriety audit can be summarized as, or the objectives can be defined like identification of wrongful expenditure. Identification of the wrongful expenditure. That means any extravagant expenditure is not made by the executive. Then promoting efficiency with respect to utilization of funds, promoting efficiency with respect to utilization of funds means optimum utilization of the financial resources. Then adhering to standards while making such an expenditure, and ensuring the accountability with respect to utilization of such public funds, and at the last we can say this propriety audit also foster an environment of good governance, and it ensures that the principal value for taxpayer money has been completely complied by the state while making any such expenditure with respect to any policy or initiative or any program of the government. Now, you can say such kind of question can always be concluded with the general statements like, here the dual role of CAG, dual role means first is with respect to legality and second is with respect to the propriety. Dual role of CAG plays an important role in safeguarding the public money, public finance, along with responsible fiscal management, thereby not only legitimizing the actions of the executive, but also ensuring the efficiency, while making such an expenditure. So again, it was a simple and a direct question. Now, the next question that we will take is, analyze the role of local bodies in providing the good governance at local level. Again, the first part of the question is again a direct and a static portion. And bring out the pros and cons merging the rural bodies with the urban local bodies. That what could be the pros and cons of merger of the rural local bodies as well as urban local bodies, that is PRI and the ULB respectively. Analyze the role of local body in providing. Now, for such kind of question, the introduction again can be that while India celebrates its 77th anniversary, independence anniversary, the third tier institution have acted as a crucial block. The third tier institutions have acted as a crucial block in promoting the democratic decentralization, in lines with principle of subsidiarity. What does the principle of subsidiarity says? That majority of the powers and functions shall be given to that tier of the government which is nearest to the people. Need not to explain this, just mention the name, in lines with principles of subsidiarity. Now the thing is that they are asking in the first part that how the third tier institutions have facilitated good governance. So strictly you have to restrict to the components of the good governance while explaining this point. Good governance in the main body, in fact we can start off with good governance and third tier institution. The first aspect would be inclusiveness. inclusiveness means the third tier institutions provide for the inclusion of all the weaker sections of the society like SC, ST and women, inclusion of weaker section of society by ensuring the reservation, by ensuring the representation via reservation policy, whereby 1/3 of the total seats are reserved for the women by a system of rotation, and the reservation is also provided for the SC and ST population in accordance with the population they are having. So they have truly emerged as the leader of tomorrow. They have truly emerged as a leader of tomorrow. In fact, it has been a very positive and transformative policy, positive and transformative policy with respect to the upliftment of the marginalized sections of the society such as SCs, STs and as well as women. Now, second aspect of good governance is participatory governance. Participatory governance. Participatory governance. The third tier institutions also ensure the participatory governance as Gram Sabha. Gram Sabha is highly empowered of a body which is responsible for the election of Gram Panchayat. Election of Gram Panchayat. And how it facilitates the participatory governance? Because this Gram Sabha is an example of direct democracy in our country. Is an example of direct democracy in our country, whereby this institution is discussing the Gram Panchayat development plan catering to the need of one village panchayat area. So the policies for the development of a rural areas are specifically designed by the people itself. So it is an example of what? Direct democracy. Now, another aspect of good governance is accountability and transparency. Accountability and transparency. How it is ensured by means of the third tier institution? The elected representatives are more connected to the local population. Now, in fact, that has been the core of democratic decentralization also. Now, the elected representative is more connected to the local population, so their accountability can be easily fixed. Then apart from that, empowerment and capacity building. That is another aspect of good governance. Empowerment and capacity building. How empowerment and capacity building is facilitated by it? The local communities are empowered by the third tier institutions, as now they are having the access to resources. And since they are having the access to resources, then they can themselves decide the optimum utilization of these resources catering to their own demand or catering to their own needs. You see, there are 29 functions. That have been given to the Panchayati Raj institution in accordance with Part 9. And there are 18 functions that are given to the urban local bodies in accordance with Part 9A of the Constitution. Accordingly, these functions as well as the resources are devolved by the state in the favor of the third tier institutions. They are having the access to resources and they can decide the optimum utilization of resources as per their own ease or as per their own requirement. It also contributes to better efficiency. Better efficiency is another good component of the good governance. Now, they have deeper understanding. The third tier institutions, they have deeper understanding with respect to the allocated resources. with respect to the allocated resources, they have deeper understanding and thereby bringing objectivity in the functioning. Bringing objectivity in the functioning. So that is how you see we can talk about how the third tier institutions have complemented the idea of good governance. Third tier institutions have complemented the idea of good governance. But you see, again, it is a question of 150 marks, so you are not having any extra leverage to write in such questions. So, in fact, the question is having three important components. The first was good governance and third tier institution, and second was the pros of merging Panchayati Raj institutions and urban local bodies. The pros of merging the Panchayati Raj institutions and the Panchayati Raj institutions and urban local bodies. Positives. They can be seen in the form of integrated planning. Integrated planning. Integrated planning and development will be facilitated by a cohesive developmental strategy. Cohesive developmental strategy, ensuring that rural and urban development, rural and the urban development complement each other. Ensuring the rural and urban development complement each other by this cohesive developmental strategy. In fact, it will provide for a holistic resource management. Holistic resource management after the merger of Panchayati Raj institutions and urban local bodies. Now, then it will also facilitate the better service delivery. Better service delivery by reducing the duplication of efforts. By reducing the duplication of efforts. Reducing the duplication of effort, you see that there are common areas of interest between the Panchayati Raj institutions and the urban local bodies, specifically those areas under transition. Those areas under transition means that the conditions are not suitable for the establishment of full-fledged municipal body or a panchayat. So, in order to, you can say, reduce the duplication of efforts and ensure the better public service delivery, the integration or the merger of these urban local bodies and Panchayati Raj institutions can be a good initiative. Then along with that, it will also lead to cost effectiveness. Cost effectiveness by reducing the administrative cost. By reducing the administrative cost along with enhanced accountability. Along with enhanced accountability due to reduction in various bureaucratic layers. Due to reduction in various bureaucratic layers or streamlining the bureaucracy network. Then it will help in effective management of disaster related plans. Effective management of disaster related plans. Disaster related initiatives or disaster related plans. How? Because the coordinated emergency responses can be designed by effective resource allocation. By effective resource allocation, the coordinated emergency response plans can be easily designed. Along with that, one more thing that we can add to it is that it will lead to cultural integration. It will lead to cultural integration by eliminating the urban-rural divide. By eliminating the urban-rural divide, it will lead to the cultural integration along with facilitating the mutual understanding between the urban and rural areas. Facilitating the mutual understanding between the urban and the rural areas. So these points are the one which can be presented as regards favoring the merger of the PRI and urban local bodies is concerned. But you see, along with this pros, there are cons of the merger also. Cons of merger of urban local bodies and Panchayati Raj institution. Now, what could be the possible constraints? What could be the possible constraints in merging the third tier institutions altogether? The constraints can be observed in the form of urban versus rural dynamics. Urban versus rural dynamics. Administrative complexity. Administrative complexity. Then loss of autonomy. Loss of autonomy for the rural institutions as well as for the urban institution. Rural institutions as well as the urban institution. Then it will lead to resource constraints, as there can be more allocation of resources in the favor of urban bodies than the rural bodies. Then it will also lead to conflict. That means it has also got the potentials for conflict. Potentials for conflict if the interest of the marginalized sections are not adequately represented. Then it will present its own set of challenges with respect to capacity building in the staff or the administrative staff, like training, staff requirement, etc. Then one more thing that we can see is that the constitutional requirement will be needed for such a merger. A constitutional requirement will be required for such a merger, and in a country like India with a diversified political culture, this itself would be an Herculean task. So accordingly, we will have certain set of cons associated with the merger. What could be the possible way forward for such questions or conclusion? The way forward, of course, it has to be optimistic in nature. Like what we can see is that this merger of third tier institutions is can be a significant step to promote the effective democratic decentralization. To promote the effective democratic decentralization, but the successful merger of the Panchayati Raj institutions and the urban local bodies will require the careful planning, then stakeholder engagement, along with addressing the needs of rural and urban areas. That is how it can be summarized. The next question that we'll take up for discussion is, the doctrine of democratic governance makes it necessary that the public perception of the integrity and the commitment of the civil servants becomes absolutely positive. Discuss. Now, it is just again a simple and a direct question, but first of all, what actually is the doctrine of democratic governance? The intro part of such questions again can be started with the definition of this doctrine of democratic governance. See, the doctrine of democratic governance, refers to a set of principles, and frameworks that underpin the functioning of a democracy. What could be such set of principles? Such set of principles include popular sovereignty, rule of law, accountability of policy makers, free flow of information, participation by the citizens, or participatory governance. So the doctrine of democratic governance, it is majorly comprised of certain set of principles that are mandatory, that are important or indispensable for the functioning of a healthy democracy, and they are a prerequisite for good governance, ensuring the social justice as well as ensuring the equitable development. Ensuring the good governance, social justice, along with equitable development. So the introduction part, hardly in 20-30 words, it can of course include the definition of this democratic governance. Now let us see how the democratic governance and civil services complement each other. In fact, that is the core of the question. How the democratic governance and the civil services, they complement each other, or what is the role that the civil services can play in ensuring the principles or adhering to the principles of this democratic governance. Upholding the constitutional spirit. Upholding the constitutional spirit, you see, India is a country with a parochial political culture, whereby the civil servants are expected to serve the two masters with same loyalty and dedication. Expected to serve the two masters of course being the central government and the state government. They are expected to serve the two masters, the central and the state government, with same loyalty and dedication. So in the spirit, they don't hinge with the son of the soil policy. And uphold the constitutional spirit. So that is how they complement what? The doctrine of democratic governance. Then along with that, as an agent of change, social change and transformation. Agent of social change and transformation, especially in the transitional society. Transformative societies like India, they play the role of an agent of social change. Here in such cases, some good examples can be quoted like Armstrong Pym, who is credited for the construction of 100 km of route, ensuring the connectivity to the nearby states. Along with that, Smita Sabharwal, for her initiative as the District Magistrate of Karimnagar, called Fund Your City Initiative. Fund Your City Initiative. Then Divya Mittal for ensuring the supply of clean drinking water to the rural household. Then Aruna Sundarajan in the field of women empowerment. In the field of women empowerment. So that is how they act as an agent of change and transformation. One more example can be given is of Amit Kataria, who has brought a positive change in the life of the people residing in the Naxal affected areas. Naxal affected areas, a positive change in the life of the people. So as an agent of social change and transformation. Then in a country with limited resource or scarcity of the resources, they equally have a very important role to play in policy making and implementation. Policy making and implementation. So here they not only provide their valuable aid and advice to the ministers, being the executive head of any ministry, but they also provide their inputs with respect to various aspects of a policy. With respect to various aspects of the policy. As they have institutional memory. As they have institutional memory. Various aspects of the policy like the feasibility of the policy. Feasibility of the policy. Like the optimum utilization of resources. Optimum use of resources. Then optimum use of resources. Then the past experience of the policies. Past experience of the policy. So you see, they are referred as permanent executive. They are referred as permanent executive. As the government will come, the government will go, but they will remain permanent and they will facilitate the smoother transaction of power from one government to other. So they have a very important role to play in policy making and the implementation of the policies. Then in administrative adjudication, they have important role to play in administrative adjudication in the form of the members of arbitration tribunals, in the form of the member of a number of quasi-judicial bodies, whereby they unburden the court of the burden, unnecessary burden that they are facing. Apart from this, the information and communication technology also brings accountability and the transparency, accountability and the transparency in the functioning of the civil servants, in the functioning of the civil servants, thereby bringing more objectivity, thereby bringing more objectivity in their functioning, thereby bringing more objectivity in the functioning of the civil servants, more objectivity in the functioning of the civil servant, as it will also reduce corruption and it will also ensure the accessibility of the administration at the grassroots level. However, over the period of time, you see, certain set of challenges have been observed. Certain set of challenges have been observed with respect to the civil services or the challenges to what we can say the principles of democratic governance, like patrimonialism, then corruption, frequent transfers, lack of recognition, frequent transfers, lack of recognitions, etc. One more if we can add is the unnecessary political interferences. That has not only hindered the effectiveness of the civil services, but simultaneously it has also affected the doctrine of democratic governance. Now, the way forward or such questions can be concluded by, you see that the strengthening of the integrity of the civil services, by ensuring their responsiveness is a crucial aspect of good governance. And the interaction or reducing the vacuum between the ordinary citizenry and civil servants or the civil services can eventually contribute to the effectiveness of the democratic system. In fact, this is one such idea which has also been highlighted by Sardar Patel. In 1948, while addressing the first batch of the civil servant, it was said by Sardar Patel that your predecessors have grown up in such an environment whereby they have been kept aloof from the normal citizenry. That means there was a vacuum between the ordinary citizenry and the civil services. But now it shall be your bounden duty to treat them as their own. And accordingly they were you can say entrusted with certain set of responsibilities also, adhering to the principles of democratic governance. That is how such questions can again be concluded. The next question is with respect to center-state relations. What changes the union government has recently introduced in the domain of center-state relations suggest measures to be adopted to build the trust between the center and the states for strengthening the spirit of federalism? Again, it is a direct question. Now, the introduction for such questions can again be started like, again as you see it is a direct question, like Dr. Ambedkar, B.R. Ambedkar, while speaking on the nature of the Indian Federation, he has said that union is federation. Though the collective meaning of Article 1 and 3 can be that India is indestructible union with the destructible states, but the nature of the polity is federal. And the two governments, that is the union government and the state government, they are not subordinate to each other, rather they are coordinative. In the performance of day-to-day functions. And accordingly, the Constitution of India provides for a threefold division of power between the union and the state in the form of legislative power, in the form of administrative power, and in the form of financial powers or distribution of financial powers. So they are also termed as legislative relations, administrative relations, and financial relation. And in the spirit of legislative, administrative, and the financial relations, the cooperative federalism is ensured, cooperative federalism is ensured between the union and state government, or the spirit of cooperative federalism is fulfilled between the union and the state. As the question has said that what are the changes that the union government has recently introduced in the domain of center-state relations. So it will include two aspects. It will include two aspects with respect to the changes. First is the positive aspect. First is the positive aspects. That means ensuring the fulfillment of the spirit of cooperative federalism, and there have been certain limitations. There have been certain limitations to the cooperative federalism, as well as you can also say that there are certain negatives that are associated with the spirit of cooperative federalism. They can be observed in the form of, like on the positive aspects, if we can see, the GST extension policy, of the union government, whereby this policy helps the states in overcoming the financial stress, Then the aspirational district program has been introduced for the development of the underdeveloped areas, and here the technical and the financial assistance will be provided by the central government. Then greater financial devolution on the recommendation of the 15th Finance Commission, whereby they have recommended the devolution of 42% of the financial resources to the states. Apart from the greater financial devolution, the Niti Aayog, the institution of Niti Aayog has been established to streamline the process of development between the center and the state, governments. Then a scheme called PM Usha scheme. It is aimed at promoting the higher education at state levels, Then further, with respect to the northeastern states, a special package of around 98,000 crore has been allocated in the 2024 budget. Then for the same northeastern part of the country, PM Divine, for filling the gaps in the infrastructure project, has been introduced. Then Gati Shakti Yojana, providing for multi-modal transport system, has been introduced. The Gati Shakti Yojana, or this Gati Shakti initiative, has been introduced. So these are the positive aspects that we have recently observed with respect to this center-state relations, which have been taken by the state. In fact, one more thing we can add over here is that under national Health Mission, under National Health Mission, the efforts have been taken by the central government for improving the health infrastructure in the state. For improving the health related infrastructure in the state. So these are the positive aspect or the multiple positive aspects of this multiple positive aspects can be seen with respect to the initiatives taken by the central government recently. But as I said, the question is talking about the positives as well as the negatives. Some negatives of cooperative federalism have been observed in the form of excessive centralization of power. Excessive centralization of power in the hand of the central government. In the hand of the central government. And this excessive centralization can be observed in the form of RTI Amendment Act of 2019. RTI Amendment Act of 2019. Now, where it is totally subjected to the discretion of the union government to determine the salary allowances and the tenure of the State Information Commission. On a number of occasions, it is also criticized on the ground that it will dilute the spirit of cooperative federalism. Then is the FRBM Amendment Act. FRBM Amendment Act, which has also limited the borrowing power, of the state government. In fact, in the year 2023, the state government of Kerala has approached against the Supreme Court with respect to the amendment in the FRBM Act. Further, issues with respect to central agencies. Issues with respect to central agencies. Some states like West Bengal, they have openly criticized the misuse of Enforcement Directorate as well as the Central Bureau of Investigation. Then apart from this, implementation of centrally sponsored schemes. Implementation of centrally sponsored schemes. As the wealthier state, they can pay for their expenses or they can pay for their, you can say, the share that they have to give with respect to the central sponsored schemes. But the poor states, they cannot afford, they have poor affordability. Then Disaster Management Act. Disaster Management Act. This Disaster Management Act, invoked at the time of COVID, resulted in more powers to the central government, and the state governments were merely reduced to the status of the department of the central government. Majority of the power, they rested in the hand of the central government with respect to invoking the Disaster Management Act at the time of the COVID-19 situation. Now, so these are certain negatives of the act. In the question, they have also asked about the ways for strengthening the center-state relations. The ways for strengthening the central-state relation. The ways can be seen in the form of regular dialogue, by re-establishing the Interstate Council under Article 263 of the Constitution. Dialogue, along with conflict resolution by means of establishment of interstate councils. Then, apart from this, there is a need for re-examination of FRBM Act. Re-examination of FRBM Act In fact, it has been said by the 15th Central Finance Commission also. 15th Central Finance Commission has also highlighted on this need. Loan Council can be established to oversee the demands of the states with respect to loan requirement. That has been the recommendation of 12th Central Finance Commission. 12th Central Finance Commission. Apart from that, the Sarkaria Commission on the center-state relation of 1983. This commission of 1983 has reflected on the need of strengthening the All India services. After this, M.M. Punchi Commission of 2007 has also asserted on the need that governor, which these days is the major bone of contention between the center and the state, he should be provided with the security of tenure 5 years. He should be provided with the security of tenure, and the impeachment of the governor shall be subjected to the state assembly. The state legislative assembly shall be one such authority in dismissing, final authority in dismissing or impeaching the governor from the office. Then, NCRWC of 2000 has also recommended that emergency and disaster management shall be included in the concurrent list. That means it shall not give the sweeping power to the central government. Then the efforts shall be taken towards decentralization of power to the state government on lines of GST Council, where the states have a major say. So these are certain set of recommendations that can be given, or suggestive measures that can be given for strengthening the center-state relation. Now, again, what could be the possible way forward for such questions? The possible way forward for such questions can be that in order to promote the cooperative federalism, as well as fiscal federalism, the mutual trust between the center and state, along with respect for autonomy and enhancing the dialogue process, greater dialogue process between the center and state is the need of hour. That means the center-state relations can be strengthened by the mutual trust between the center and the state government, respect for each other's autonomy, as well as enhancing the dialogue process. That is a requirement for cooperatives as well as for strengthening of the fiscal federalism also. Now, the next question is, citizen charters has been a landmark initiative in ensuring the citizen-centric administration, but it is yet to reach its full potential. Identify the factors hindering the realization of its promise and suggest the measures to overcome them. Again, it is also a direct question. This has been asked in 250 words. The introduction for such a part can be initiated with the definition of the citizen charter in itself. Like, citizen charter is a set of commitments, made by a public organization towards standards quality standards, quality, choices, that means availability of choices, accountability mechanism, of the services provided by such an institution, provided by such a public organization, and an effective grievance redressal mechanism, in case these aforesaid commitments are not fulfilled. In case these aforesaid commitments, they are not fulfilled by that organization. So, citizen charter, you see, as the first part of the question says, that it has been a landmark initiative in ensuring the citizen-centric administration. Citizen-centric administration and citizen charter. Citizen charters. Citizen charter and citizen-centric administration. How citizen charter has ensured the citizen-centric administration? That means majorly the advantages of the citizen charter they are talking about. First is enhancing the service delivery, by bringing efficiency and responsiveness, in the functioning of the public organization, enhancing the service delivery by promoting efficiency, bringing efficiency and responsiveness in the functioning of the public organization. Promoting transparency. How the transparency is promoting? By ensuring the availability of choices wherever possible, by ensuring the possibility of the choices, availability of choices wherever possible, along with declaring the rights of citizens, rights and responsibilities of the citizens, with respect to citizen charter. Now, rights and responsibilities of the citizens with respect to the charter. Now, along with this, it has also ensured the accountability of the public officials. As citizen charter is also based on the principle of value for taxpayers' money. It is also based on a principle called value for taxpayers' money. How it has ensured the accountability? Because you see that since these public services are funded by the public's money, indirectly, so these officials responsible for the dissemination of the public services shall also be held accountable for their actions. Along with fixing the accountability in the citizen-centric administration, it has also ensured the empowerment of the citizens. As we see, because citizen charter is a visionary document that help in establishing the maxim, that is, the power of the people is always greater than the people in power. Power of the people is always greater than the people in power. So it has resulted in the creation of an well-informed citizenry. And one last, it has facilitated the effective grievance redressal. grievance redressal in case the commitments that have been promised by these institutions are not fulfilled. They are not fulfilled in case the commitments that have been made by these institutions, public institutions, have not been fulfilled. So that is how the citizen charter has resulted in creation of an citizen-centric administration. Now, limitations of citizen charter. Directly they have asked this: what are the limitations or what are the factors that are hindering the effective implementation of the citizen charter or obstructing it from reaching its fullest of the potential? These factors can be seen in the form of no statutory backing. No statutory backing. So, since there is no statutory backing, it becomes an optional provision. It becomes an optional provision for the government departments. Optional provisions for the government department. The language of the charters are complex. The language of the charters is complex, and it is far beyond the understanding of the common man. Far beyond the understanding of the common man. And further, majority of the charters have not been formulated in the vernacular language. In the vernacular languages. So, again, restricting the potential of the citizen charter. Then the charters is not subjected to periodic review. The charter is not subjected to any kind of periodic review, means the charter has become a one-time activity once it has been formulated by the departments. First of all, there is no uniformity with respect to the formation of the citizen charters. Even if some departments have formulated the citizen charter, they are not subjectively being reviewed. Now, apart from this, no accountability of head of department. No accountability of the head of the department. The head of the department is not accountable for the in case the standards that are supposed to be fulfilled are not met. Now, then lack of awareness. Lack of awareness. The people have limited awareness. The people have limited awareness or poor awareness with respect to citizen charter. Then along with the limited or the poor awareness, other limiting factors can be seen like excessive centralization. Excessive centralization in formulation of charter. Excessive centralization in formulation of charter means, like you see, that it is only the top brass of an institution which is majorly responsible for the formulation of citizen charter, and no help of the, you can say, the field staff. No role of field staff is ensured while formulating the citizen charter. So, it is having its own set of limitations. Now, so these are certain set of limitations. Accordingly, there could be certain set of measures which can be taken, suggestive measures that can be taken to ensure the effectiveness of the citizen charter. Some of them have also been recommended by the second ARC, second Administrative Reforms Commission, like establishment of grievance redressal mechanism network. Grievance redressal mechanism network. Then formulation of feedback mechanism. Formulation of the feedback mechanism. A feedback mechanism can be developed. Then one size fits all. One size fits all approach shall be denied. That means different charters shall be formulated for different departments. A single unified charter cannot be formulated for multiple number of departments. Then it can be linked with, citizen charters can be linked with e-governance initiatives. They can be linked with e-governance initiatives to make it more user friendly. To make it more user friendly, it can be interlinked with the e-governance. Then apart from the interlinking with the e-governance projects, the dissemination or disbursement of the best practices, that means dissemination and the disbursement of the best practices with respect to the citizen charters, they can be followed as a model. Statutory recognition or the legal recognition to the citizen charter. Legal recognition to citizen charter will ensure that now it will be obligatory for the government departments or the public departments to formulate the citizen charter. Now, then the civil society organizations involvement can play an important role in formulation of citizen charter, as they have wider experience of governance at the grassroots. Level. So there can be an active involvement of civil society organizations in formulation of the citizen charter. So that is how you can see there can be multiple number of measures that can be taken for the citizen charter. One more, like if you can see, the accountability of the head of the department shall be fixed. Then the charters shall be formulated in the regional language. Vernacular languages, etc. And there shall be an active involvement of the field staff. While formulating the citizen charters. And there can be an assessment of the citizen charters by the nodal departments. So a nodal department can be formed for the assessment of this citizen charter. So what could be the possible way forward for it? The possible way forward for the citizen charter can be seen like that citizen charters have played an important role in ensuring the citizen-centric administration in the spirit of good governance. By fixing the accountability, ensuring the free flow of information or transparency, ensuring the availability of choices with respect to the delivery of public services. But the periodic evaluation, the legal or the statutory recognition, along with the involvement of the other stakeholders, can be effective measures in realizing the potential of the citizen charter to its fullest. Right? That is how such questions can be concluded. So now one last question is with respect to e-governance. This question says that e-governance is not about the routine application of the digital technology in the service delivery process. It is as much about the multifarious interactions for ensuring the transparency and the accountability. In this context, evaluate the role of the interactive service model of the e-governance. Now you see. So again, this question, it is having two important aspects. One aspect is with respect to the multifarious interactions for ensuring the transparency and the accountability, and the second is with respect to evaluation of this interactive service model. Again, such questions can also be directly, you see, started off with the introduction like e-governance is the use of information and communication technology in delivery of services. In delivery of services, it ensures accountability, transparency. It ensures the accountability, transparency and responsiveness. Accountability, transparency and responsiveness in the effective service delivery. In the effective service delivery. Now the second part they have said is it is as much about multifarious interaction for ensuring transparency and the accountability. The multiple aspects of this e-governance, they can be seen in the form of like the three important pillars of e-governance, as we can observe: effectiveness in the e-governance, accountability in the e-governance, as well as transparency in the e-governance. So what we see is that e-governance not only improves the government efficiency by streamlining the process, by reducing the paperwork and automating the task, but also leads to faster service delivery. Like one such example is Aadhaar. Multiple number of programs are the one which are linked to Aadhaar. Like one famous one is DBT, Aadhaar linkage. DBT, Aadhaar linkage program. Also the bank Aadhaar linkage program. Manrega, just to streamline the centrally sponsored scheme Manrega, it is also interlinked to Aadhaar. Now it also ensures the accountability in the e-governance. Accountability, how? By enabling the citizens to monitor the officials and the programs via online complaint filing, as well as tracking the status. That can be observed in the form of the platforms like PMO PG, Prime Minister Office Public Grievance Portal. Along with the PMO PG, you can see there are CPgrams. Then along with that, rti.gov.in. Then there are certain set of applications like Audit Online, specifically in the Panchayati Raj institutions. Now, so this is how they also ensures the accountability in the e-governance, making the officials more responsive to the concerns of the citizens. Simultaneously, it also promotes the free flow of information. Free flow of information, ensuring the transparency in the governance by online accessibility of government data, including the budget reports, performance records, etc. Now, on a number of occasions, the official websites, they also offer the citizens with respect to passport applications. Like under e-governance, there are multiple set of models. Like one common model is government to citizen, G2C. Under government to citizen model, these passport applications, the first part of it now can be completed via the online platforms. Now, this is how they are involving the multifarious aspect. The e-governance involves the multifarious aspects. The second question is with respect to the interactive service model. Interactive service model. What is this interactive service model? This interactive service model is based on two-way communication. It is based on two-way communication between the citizens and the service providers, majorly public officials. Two-way communication between the public officials and the citizens. That means, what does it mean? It simply means that the state on the one hand and citizen being on the other hand, the state is not only providing the services to the citizens as a part of the concept of welfare state. As a part of the concept of welfare state, the state is not only equipping the citizens with the welfare services, but simultaneously citizens also have the right to not only ask the questions, but simultaneously fix the accountability as well as ensuring the transparency in the delivery of the services. That is the core, or that is the crux of this interactive service model. Now, what are the major aspects or the major facets or the major features of this interactive service model? This interactive service model has various features like it ensures two-way communication. It ensures the two-way communication between the citizens and the public officials. Now, Now it is something which is an improvement over the traditional system whereby no feedback as such was provided, but here by means of the feedback system, by means of the grievance redressal mechanism, the two-way communication can be facilitated. Then along with that, it also ensures the participatory governance. Participatory governance because the citizens by means of the online platform can now directly participate in the decision making, thereby promoting what? Direct democracy. One such example can be seen in the form of this platform mygov.in, whereby the government of India is inviting the viewpoints of the citizens on various policy matters. Then it also enhances the transparency and accountability of the public officials. Transparency is also maintained with respect to free flow of information, and accountability is also ensured of the public officials. Now, because this is how the system is streamlined by providing for all those facilities by the online medium. But along with this, you can say playing a very important or the cardinal role, being a very important component of the e-governance initiative, this interactive service model, it is having its own set of challenges that can be seen in the form of digital divide in the country, that can be seen with respect to the cyber security concerns, that can be seen with respect to the limited awareness or limited or poor functional literacy. Along with the poor functional literacy, then you see this another challenge can be seen is with respect to interoperability of the application. Then hardware related challenges are equally some set of challenges, or you can say some factors which are hindering the effective implementation of this interactive service model. So to sum up what we can say is that this interactive service model, it follows a transformative approach. In public administration with its priority towards engagement of the citizens, ensuring the transparency, bringing responsiveness in the administration, and empowering the citizens. But however, in order to realize its fullest of the potentials, we need to overcome the limitations or the shortcomings of this model. Shortcomings can be seen in the form of these limitations itself. So that is how this interactive service model can be explained. Now, so this is something like out of the box question that they have asked with respect to interactive service model, because generally this is not a part of the GS. It is a part of generally that is referred in this public administration. Anyhow, that is all we have for the day. I hope you had a wonderful mains. Lots of wishes.